what happens? You remember a phrase you learned in law school? Res ipsa. Res ipsa loquitur. The thing speaks for itself. The document speaks for itself. The injury speaks for itself. Can you use that legal doctrine to show that your client has a valid basis for a case? The answer is yes, you can. But let me share with you an interesting quirk. So let's say, for example, patient goes in to have surgery on his right hand. He comes out of surgery and he's got a third-degree burn on his shoulder in addition to the surgery they did on his hand. How could this possibly have happened? He had nothing to do with shoulder surgery. This was a hand surgery problem. He comes out of the operating room with a third-degree burn. Well, was he under the control of the people in the operating room? Absolutely. Was he under anesthesia? Yes. Could he possibly have contributed to this injury by himself? No. But for the defendant's negligence, the doctor, the nursing staff negligence, this injury would not have happened. Do we need, first of all, can we use that argument? Yes, we can use it in our pleadings. Do we need to bring in a medical expert to explain to the jury that, hey, if you go in for hand surgery, you shouldn't be coming out with a third-degree burn to your shoulder? The law says no. We don't need to bring in a medical expert to explain something so obvious to a jury. It's only where things become complicated and the jury doesn't understand the medicine involved. But I will tell you, here's the quirk. You will find that every experienced or good medical malpractice attorney who handles these cases will always bring in a medical expert, even though they don't need to, in this res ipsa case. And that's because we want the jury to understand why this injury occurred. We want the jury to understand what type of injury this gentleman received. We want them to know how debilitating and what treatment he needed in order to fix this problem. So yes, the law does not require us to bring in an expert where it's a res ipsa case, but we can only use this argument and this claim if the patient was under the exclusive care and control of the doctors in the operating room and the staff. The patient did not contribute whatsoever to this injury, and but for the defendant's negligence, carelessness, this injury never would have occurred. So that's another way that we can use that. So when you're listening to this person tell you about, hey, let me tell you about my tale of woe, what happened. I went in for surgery and I wound up with some problem to my foot or to my brain, whatever it is. You may be thinking, hey, you might have a case here and you might be able to use res ipsa. And that's important to know.